A bipartisan group of 35 former judges filing a striking brief calling for an investigation into that settlement that led to the creation of President Trump's $1.8 billion, what he calls the anti-weaponization fund. The deal was struck in exchange for Trump dropping his lawsuit against the IRS. It also grants him, his family, and businesses immunity from ongoing inquiries into their taxes. It calls the settlement a product of collusion and is itself a fraud on the court. With me now, one of the judges who filed that brief, Shira Scheindlin, retired U.S. District Judge in the Southern District of New York. There has been a lot of hue and cry about this deal. Tell us why it was important for all of you to get together and write this.
We thought it was very important because the court plays a role in our government, and it shouldn't be used as a way of doing something that otherwise couldn't be done. And so the court was really used, so to speak. There was a fraud on the court because this was a collusive lawsuit. There may not have been a real case and controversy because President Trump was on both sides of the case, right? He's the president and he's suing his own agency, which he basically controls. So it was a way of making a deal that would then support this anti-weaponization fund and his own immunity, which was never disclosed to the court. So when you have a fraud on the court, former judges care about that.
So when you short circuit, essentially, a judge's ability to examine settlement terms, obvious question is, how do you even do that?
Well, that's not exactly what was short-circuited.
Okay, tell us.
It wasn't the settlement terms. What was really short-circuited is whether there was a really honest case or controversy. If there was no case, then the court had no jurisdiction, and you couldn't settle a case that doesn't belong in the court. So you take away the underpinning of the entire so-called settlement, which is based on that case. It even uses the caption. It says, this case was filed and now we're settling this case. 2 days later, she was to receive briefs. The judge was to receive briefs as to whether there was a real case or controversy. But by rushing into court on that day, on May 18th, she never saw those briefs. She never got a chance to rule. And we don't know if there was a real case or controversy.
And did she have any options?
Well, she didn't know about this settlement. She was just told this is a voluntary dismissal with prejudice. She didn't have any questions. She made a statement. She said, on the record, and there's no settlement on the record. So she assumed there was no settlement. They just were dropping the case. But that turned out to be a fraud because on that very same day, May 18th, the settlement agreement was signed. The document is signed by the then, I think, Deputy Attorney General Stanley Woodward signed that document on the same day. But nobody told the judge. So she didn't know that they were going around her to figure out whether there was a real case or controversy and whether there was a settlement. Because she even said, there's no settlement.
So realistically, can anything be done about this now?
Oh, yes. There's a rule, Federal Rule Civil Procedure 60, that would allow her to reopen this case because a voluntary dismissal with prejudice is a final judgment. So she can reopen this case either on the motion of one of us, the 35 judges, or on her own. It's called sua sponte, which means on her own motion. She can reopen the case and she can examine now, conduct an inquiry. Was there ever really a case or controversy? And let me explain what I mean by that. When a similar case was brought by other plaintiffs who said our tax returns were wrongfully disclosed, the government fought that and said, well, the guy who disclosed it wasn't even a government employee, and it's the same guy. It's a guy named Littlejohn. So they had defenses, plus it wasn't even timely. This case should have been time barred. So the government in the past has fought those kind of cases. This time, they just made this deal, which has these two prongs that you talked about, this terrible anti-weaponization fund of $1.776 billion and total immunity for Trump and his family for everything done up to the day of the settlement. But there can't be a settlement if there's no case.
When you look at this and well beyond this case, what's your observation about the pressure and the changes that the president of the United States is essentially forcing on the judiciary these days?
Well, you say forcing. I think the judiciary certainly in the lower courts, the trial courts and the circuit courts, has been the guardrails, has stopped many of the things that the president has tried to do to sort of get around the judiciary or neuter the judiciary.
Yeah, by forcing, I meant they're looking at things that they've never really
Well, that is certainly
before.
true. But, for example, as you know, they stopped his tariff decision. And then it gets to the Supreme Court. And typically the Supreme Court has then overruled the lower courts and let the things he wants take place. But in the tariff case, they stopped it. And in a couple other cases, the Supreme Court has stopped it. Mostly they haven't reached the merits. They've done this thing called the shadow docket, where as an emergency effort, they let the president's actions continue, as they did with the tariffs, even though they had to have known they were probably overturned. So it went on for another year.
Shira Scheindlin, it's fascinating stuff, and you make it all very understandable. Thanks for coming in.
Thank you for having me.